What are the top 5 things I need to do after a loved one dies? Losing someone close can make even simple decisions feel overwhelming. In the midst of grief, there are also important legal and practical steps that need prompt attention. Understanding how Texas law handles a loved one's passing can help protect their legacy and ease the burden on the family. When a death occurs, the first priority is to secure an official pronouncement of death. In hospitals or nursing facilities, staff handle this task, while hospice nurses have authority to pronounce death at home. If death happens unexpectedly at home, calling 911 ensures that a physician or medical examiner completes the pronouncement. This step allows a death certificate to be issued, which is essential for funeral arrangements, closing accounts, and claiming benefits. Families should also check whether the deceased left written funeral instructions or prepaid contracts. Texas law outlines who may make decisions when no instructions exist, starting with a designated agent, then the spouse and adult children. Veterans may qualify for burial benefits through the U.S. Department of Veterans Affairs, including interment in a national cemetery. After immediate concerns are addressed, gather essential documents. Order 10 to 20 certified copies of the death certificate, because banks, insurance companies, the Social Security Administration, and the probate court require originals. Funeral homes in Texas often request them for you, but copies can also be ordered through the Texas Department of State Health Services or a county clerk. Locating the original last will and testament is critical. Texas courts require the original, and treating a will as lost increases costs and complexity. Look for trusts, powers of attorney, or letters of instruction, and check with the county clerk to see if the deceased deposited a will there. Organizing financial documents, deeds, tax returns, personal identification, debt records, and online account information into a master file streamlines administration. It is important to understand who has legal authority to administer the estate. The personal representative is either an executor named in the will or an administrator appointed when someone dies without a will. A named executor lacks authority until the probate court appoints them and issues letters testamentary. If there is no will, the court appoints an administrator and issues letters of administration, following a statutory priority list that begins with the surviving spouse and then adult children. Because an estate is considered its own legal entity, a non-attorney personal representative cannot represent the estate in court. Texas law generally requires hiring a probate attorney. An attorney assists with filings, notices to creditors, and compliance with the Texas Estates Code, and helps protect the representative from personal liability when paying debts and distributing assets. Working with a lawyer who understands probate rules can minimize mistakes and reduce the risk of lawsuits from beneficiaries or creditors. Once a personal representative is appointed, the formal estate administration begins. This involves notifying government agencies and financial institutions. The Social Security Administration must be contacted promptly to stop benefits and advise on survivor benefits. Veterans Affairs should be notified to terminate benefits and determine whether survivors are eligible for pensions or burial assistance. Banks, credit unions, and brokerage firms need certified death certificates to freeze accounts and prevent unauthorized withdrawals. Life insurance companies, pension administrators, and credit bureaus also require notice. The deceased's driver's license should be canceled with the Texas Department of Motor Vehicles to guard against identity theft. Paying debts must follow a formal creditor claim process. Texas law requires publishing a general notice to unknown creditors within 30 days of appointment and sending direct notice to secured creditors within 2 months. Representatives may also send optional notices to unsecured creditors. If they do, those creditors must file claims within 4 months or lose them. An inventory of the estate's assets must be filed within 90 days, listing all probate property and assigning values. Probate assets, such as solely owned real estate, personal property, and accounts without beneficiary designations, are subject to court supervision. Non-probate assets, like life insurance with named beneficiaries, payable on death retirement accounts, or jointly owned property with rights of survivorship, pass outside probate. The probate system offers several paths to settle an estate. Independent administration is common when the will authorizes it or heirs agree, giving the executor broad authority with minimal court oversight. Dependent administration requires court approval for most actions and is used when a will directs it or when family disputes require supervision. Probate as a muniment of title is a simplified option when there is a valid will and no debt other than a mortgage. For estates valued at $75,000 or less, excluding the homestead and exempt property, a small estate affidavit allows heirs to collect assets without a full probate proceeding. Final tax obligations include filing a last individual income tax return, an estate income tax return if the estate earns more than $600, and a federal estate tax return only for very large estates exceeding the exemption amount. Only after paying all debts, taxes, and expenses can the personal representative distribute assets, obtain receipts from beneficiaries, and close the estate. The passing of a loved one is never easy, but understanding these steps helps families navigate a challenging time. Addressing immediate needs, locating documents, confirming legal authority, following the probate process, and choosing the right procedure all protect a legacy and honor the deceased's wishes. Working with an experienced Houston probate lawyer ensures that the process complies with Texas law and that your family receives compassionate guidance. For assistance, contact the law office of Whitney L. Thompson, PLLC, at 4201 Farm to Market 1960 Road W, Suite 360, Box number 116B, Houston, Texas, 77068. You can reach the law firm by phone at 281-214-0173.